This bill calls on the federal government to hold a constitutional convention at the federal level, which is a power that states have that's rarely exercised. If 2/3 of the states call on the feds to hold a constitutional convention, one will happen, and it's never actually manifested before, but it's a tool that the states have used powerfully on behalf of the residents in the past. And for instance, the 17th Amendment, the amendment that says that federal senators shall be elected, was moved through the Congress only after 2/3 of the states minus one had called for a constitutional convention to address the issue. So we've never got into a constitutional convention as such before, but the states agitating for one has forced the federal government's hand to do what's right for the people. And we're in a similar situation now where the Supreme Court has recently ruled that corporations can spend as much money as they care to in our elections at the local level in Rhode Island or at the national level. And it looks as though the federal government is not going to address it or will not address the issue in a way that's sufficient at the very least. And so this resolution calls on Congress to hold a constitutional convention specifically to try to address the Citizens United decision. The amendments are put forth and need to be ratified by 3/4 of the states. And so anything that's too extreme on the left or on the right or otherwise inappropriate that might come out of that convention could easily be rejected by 1/4 of the states and by half of the legislative chambers therein, so by 1/8 of the legislative chambers across this country. So the things that would emerge from a convention that might actually stand a pass of becoming vested, of becoming a part of our Constitution, are the ones around which there's some broad consensus, left and right, geographically, and so on. And those, namely, are probably the issues of good governance, like campaign finance reform. And it's imperative that we address these issues sooner rather than later, because as people start to get elected based upon these new structures, they're going to have every added incentive to maintain the status quo, to maintain the structures that help them achieve election in the first place, and it will only become harder to reverse this decision. And so with that, I will defer to the several witnesses.
The first witness that we have. Larry Lessig. Is Mr. Lessig here?
Thank you very much, Mr. Chairman. My name is Larry Lessig. I'm a professor of law at Harvard, and I'm very honored to be down here to support the resolution that Representative Segal has introduced, asking the federal government to call for a federal constitutional convention. I understand that Rhode Island is a blue state. I see this reinforced by the colors on your wall here. But if this were a red state, Utah, or if this were a purple state of Ohio, there would be no difference in one fundamental view that Americans hold across all of our country, and that is extraordinary skepticism and cynicism about the way our United States Congress functions. The current integrity representation of Congress is at its lowest level in the history of Congress. Less than 22% of Americans now have any faith in the United States Congress. Probably more people supported the British Crown at the time of the Revolution than support our Congress today. And that's not because our Congress is corrupt in a traditional sense of corruption. It's not because Rod Blagojevich types are all through the United States Congress. Indeed, our Congress is probably the cleanest Congress in the traditional bribery sense of any Congress since the beginning of the founding of this republic. But instead, people are cynical about this Congress because people see Congress people constantly focusing their attention on the single, perhaps most important job that they've got, which is raising money to get back to Congress or to get their party back to Congress. Estimates are between 30 and 70% of a member's time is spent in the business of raising money to get back into Congress. So they've developed a second dependency, a kind of sixth sense about how every decision they make might undermine or weaken their ability to raise the money that they need or their party needs to get back into power. And the result of that is that most Americans view what Congress does in an extraordinarily cynical way. And the past 18 months since the election of Barack Obama has reinforced that cynicism, as every major reform that was pushed by this administration has been blocked by extraordinary type of reform. Now, the framers of our Constitution recognized that a Congress sitting in a single city could be corrupted in this sense precisely. And again, I want to be very clear. I don't think this Congress is corrupt in any criminal sense of the term, but corrupted in the sense that it's no longer focused on the primary objective of Congress, which is to represent the people. And our framers understood that if a Congress became corrupted in exactly that sense, the only way to check that Congress, the only way to change it, is for the states to stand up and to take the responsibility our Constitution gives them to take control of the process away from Congress for the purpose of asking whether there are changes to our Constitution that are necessary.
What initiatives have been proposed at the federal level upon which Congress has, at least to date, failed to act? What chance there is for some reform of this issue actually following from their work?
That's right. So immediately after Citizens United was decided, and actually more precisely after the pollsters came back and told Republicans and Democrats alike that close to 83% of Americans were opposed to the decision of the Supreme Court and Citizens United, there was a raft of amendments that were proposed by members of Congress, some of them to reverse the decision directly, some to declare that a corporation is not a person, some to engage in much more substantial changes to the free speech clause of the First Amendment. And all of these proposals were offered as if there was some meaningful chance that Congress would take them up, when anybody who knows how to count to 67, which is the number of votes one needs in the United States Senate, realized there was zero chance that any of these proposals would go anywhere in the United States Senate. At least. And 4 months after this decision's come down, nothing has happened on any of them. And nothing will happen on any of them, because the existing system in Washington depends upon continuing this system in exactly the same way. That's why the framers' only hope here, people outside of Washington, is the one way that we could begin to create the pressure to make some type of change here. And that's I think, the purpose behind your proposal.
Thank you, Representative Segal. Are there any further questions for the professor? Seeing none, thank you for joining us,
Thank you, sir.
Professor. Have a safe ride back to Cambridge. Steve Brown. Steve, are you here? Steve? Welcome, Steve.
Thank you, Mr. Chair, members of the committee. On behalf of the ACLU, I'm here to express our organization's opposition to this resolution. I am not here to debate the merits of the decision in Citizens United, only to say that the ACLU is an organization that does not feel that it was the end of democracy, but in fact we believe that the decision in many respects upheld very basic principles of the First Amendment. What I do want to talk about is the process, the procedure that this resolution attempts to use in order to overturn that decision, and we are very concerned about it for a number of reasons. First and foremost, regardless of which side one comes down on in the Citizens United case, this is a request for a constitutional convention to adopt a constitutional amendment that would, for the first time, actually restrict what the First Amendment has been held to protect. We are strongly opposed to even the notion of considering a constitutional amendment that would do something like that. And I would only point out that there are many other First Amendment decisions that the U.S. Supreme Court has issued over the year that has generated as much, if not more, controversy, and that would be just as amenable to a constitutional amendment or a constitutional convention. And some, in fact, have been the subject of proposed constitutional amendments. The most obvious one, the quintessential example, are the Supreme Court's decisions ruling that burning of the flag is protected by the First Amendment. That generated enormous outrage, I think probably even more than Citizens United did. There were there were proposals to pass a constitutional amendment. The ACLU opposed those amendments for the same reason that we oppose something like this. But this does one thing further. It not only is an attempt to propose a constitutional amendment, it proposes a constitutional convention. As Professor Lessig mentioned, there has been lots of discussion in both the academic and judicial community about what that means. Could, in fact, a constitutional convention once called be limited to the specific purpose for which it was called? Professor Lessig thinks it could be limited. There are many others who believe just the opposite, and who have argued that once this convention does take place, the entire Constitution is open for discussion and amendment. Now, it is true, as Professor Lessig said, that anything that came out of this convention would need to go back to the states for approval. But I'm not sure it's in the best interests of this country to be spending hours, days, weeks, and months discussing some of the most controversial issues in this country as to whether they should be part of our Constitution. Regardless of whether it's a red state or a blue state, a red state issue or a blue state issue, this is not how legislatures in the 50 states should be debating very controversial issues.
Thank you, Mr. Brown. A question from the sponsor, Representative Segal.
Just thank you, Steve. And just wondering why you don't think that it's appropriate for people to gather to have those conversations about the controversial issues, particularly understanding that it would require an overwhelming majority of members of state legislatures in order for any of these amendments to be adopted. I mean, you could look at the Congress as an ongoing constitutional convention in some sense, because they have the right to propose amendments as they care to at any time. So why would this be, why is it something to be so fearful
Well,
of?
I have nothing against conversation. I think conversation about these issues is perfectly appropriate. The question is, should the formal calling of a constitutional convention be the way that these discussions occur? I think there's a good reason that it has not happened in 200 years, and a good reason for it not to happen for another 200 years. Have the conversations, have the discussions, discuss legislation in Congress, to consider ways, if one wishes to, as to how to limit, to the extent constitutionally permissible, the Supreme Court's decision in Citizens United, but to actually go this extraordinary, and it truly is an extraordinary and precedential step of calling a constitutional convention is not, we think, the way to have a conversation about an issue like this.
And I would say this is an essentially different issue that's much harder to address in the ways that choice or some of the other issues you mentioned might be addressed, because it gets to the heart of how the structures of our federal system are established. I mean, they themselves are what is in question here, and that's why it seems so impossible to leave it to the people who are elected per those structures to make the decision to try to reform those structures. It's why there needs to be some outside check in this particular circumstance as I see it, and it's distinct from those other issues as such.
I disagree, but I won't get into a long discussion.
Are there any further questions from Mr. Brown?
Thank you.
Mr. Brown. I think the walls may have been shaking throughout the building. In addition to Representative Walsh and Representative Ruggiero, I see in the middle of this discussion about the Constitutional Convention, Representative Gemma has just joined us also in the crowd. So welcome, Representative Gemma, to House Judiciary. Somebody else who served at the last Constitutional Convention here in Rhode Island with Representative Driver. That concludes the hearing on H8186. The next bill we're going to take up is by Representative Martin.